Madam Clerk, can you,
Yes.
you can hear me, and is my picture coming through? Because on my big screen, it was
It's
looking frozen. I think,
coming
okay,
and going.
okay.
Okay. So I'm not seeing the jail coming on right now. So can we start with Judge Bates' cases? Okay,
I'm fine with that.
start with Rogerson case.
Is Mr. Needham present and
He
Mr.
is.
Rogerson present?
Yeah, both of them are. Both coming in.
I believe Miss Dew should also might be in the waiting room too.
Okay, are both parties ready to proceed in the Rogerson matter?
The defense is, Your Honor.
The city is as well, Your Honor.
Okay. There was, I noticed a couple things I wanted to just get clarification on. We had proceeded with a plea. However, I was going back over the statement of defendant on plea of guilty, and I don't know whether or not it was addressed. If the parties have that, page 5, the last paragraph on the bottom of that page. That is a box that was not checked regarding cases that are amended to reckless driving where there's been a prior in the past. Did we go over that?
Your Honor, I don't believe we did. Essentially, it, I recall correctly, requires an additional ignition interlock period. Correct. I think is the only additional requirement.
And Mr. Rogerson has been made aware of that by council?
We've talked about that in our discussions. Mr. Rogerson has had an ignition interlock device on his vehicle since this case started back in September of 2019. So by virtue of the credit for time installed, he's going to receive credit for those 6 months. But yes, he should be made aware that the reckless driving plea would carry an additional 6 months of ignition interlock because of his prior history in 2015.
Your Honor, are you talking about paragraph T?
Let me get back to page 5. Yes, little t.
So that actually looks like the paragraph regarding the this counting as a prior, since it was amended from a DUI, not the ignition interlock provision.
Correct, but what we're getting at is because of priors, I just wanted to make sure that the defendant is aware and has been advised with priors that he's aware that DOL could impose additional requirements besides just a 30-day suspension that is noted in the statement. And it sounds like Mr. Needham has discussed that with his client, so we've clarified that. And then the last thing, it's been a while since we went through with the sentencing, but I also noticed section 11, the statement of facts is left blank. And did the parties give a recitation of the facts on the record? I just simply don't recall because it's been a couple months.
Your Honor, for purposes of this plea, I can certainly set forth in re bar facts that if Mr. Rogerson had elected to take this case to trial, the jury would have believed all the evidence. There was a per se DUI case here with a .14.
Okay.
So he's certainly agreeing to enter a plea of guilty to reckless driving on the basis that had the case gone to trial on the more serious DUI offense, he would have been convicted of that. And so he wants to avoid those consequences.
Okay. And now that you mentioned in re bar, I believe you made that statement on the record at sentencing before I accepted his plea. So, well, that clarifies a few things for me. I just wanted to make sure we had a clean record there. And we are here for sentencing today. I received some information previously. I believe the city more than likely received it. We received a evaluation, some certificates of completion. Mr. Duncanson, did you receive that information?
Yes, I did.
And then defense counsel had submitted a memorandum. I had asked the parties to do briefing regarding statements made at sentencing, and primarily there's not a whole lot of authority on that. Mr. Duncanson, do you want to weigh in?
So when I was doing my research, I found much of the same information as Mr. Needham did. There seems like it's basically up to the court's discretion. As part of that, not the last time this was scheduled, but 2 times ago, we had continued it. I had gotten a statement typed up from the person who wanted to speak and provided that to Mr. Needham. So he kind of has an idea of what the statement will be about.
Okay. Well, I haven't made a decision yet. Mr. Needham, did you receive that statement?
I did receive that statement, Your Honor. It does appear as though under sentencing case law, at least in district court cases, municipal court cases, there is no clear guidance on it. It all appears to be discretionary with the court.
Okay.
As a parent, I can certainly empathize with the family and what they had to go through 5 years ago. Obviously, my concern here, to some extent, we're here back for the same offense. No questions there.
Mm-hmm.
But there's a lot of emotion. And my concern here is that when that's mixed with what we're having to deal with here today, it has the capability to dramatically affect everyone's view of the case.
Okay. Mr. Duncanson, let me ask you a question. I have Mr. Rogerson's full case history here. I can see that he has appears 2 prior DUIs, a minor possession and consumption. Those appear to be the alcohol-related offenses. How are statements from individuals not factually connected to this case? I guess, what is the purpose for the court to listen to statements regarding a prior offense? How does all that come in? What's the city's position? Because I have the criminal history here.
Yeah, so the city's position is more or less it will help enlighten the court to, I guess, the personal cost of driving on it with a DUI. That's basically, from looking over Ms. Dew's statement, it's not really going towards the specifics too much about the prior DUI. It's more or less her concern of this happening in the future again. And more importantly, or more seriously, if something happened like 5 years ago happens again.
Okay. Mr. Needham, anything you'd like to address regarding what the prosecution has said?
No, Your Honor.
Okay. Well, here's what I'm going to do. I'm going to let Ms. Dew make her statement. I'd like the statement to be limited to no more than 2 minutes. And while I'm happy to listen, my decision regarding sentencing will be based much in part on what I see on his past history, but I will allow her to make a speech, and I can't say that's going to affect my decision at sentencing, but I don't know if I don't believe there's much weight the court can put into that, but I'm willing to listen to a statement.
Thank you.
And so we have the record open for, I believe it is Dorothy Dew, prior to the sentencing of Joseph Rogers. I understand she wanted to make a statement, so now's the time to do so.
Your Honor, you've read my statement, my concern, and I have forgiven Mr. Rogerson for what he has done to our family. My concern is that his behavior stops, and his history doesn't show that it does. In his own statement, he said that he sees no big deal in drinking and driving, and it is a big deal. It affects not only my granddaughter, my nephew, and their friend that was killed at the peak of their life. It affects the kids that were in South Bend when school was being released and he was drinking and driving. That is a big deal. And I believe in our court system 100%, and I believe in leniency 100%. But he's been given that, and he hasn't shown that it's changing his life. And sometime or another, our laws have to stand up for our youth. And that's what my statement is.
Okay. I guess we will move on to sentencing. City, anything the city would like to add regarding sentencing?
So it is an agreed recommendation. I'd ask just the court to follow it. Basically, the purpose of the recommendation is it's my position that jail itself, I don't think will necessarily benefit Mr. Rogerson, but based reading through his alcohol evaluation, it seems like if he stays on track with that, then we will have a good outcome of this. But to make sure that he stays on track with that, that's why we're requesting the EHM and Scram to kind of keep the court involved and over his shoulder and making sure that he follows through with everything.
Mr. Needham?
Thank you, Your Honor. This case has been a long time coming. It's certainly not an easy one to work your way through. When I first sat down with Mr. Rogerson, he was in custody in Lewis County. That case, as Stu has pointed out, took the lives of several people, very tragically. And at the time that the dust settled, Mr. Rogerson was charged with a DUI, not vehicular homicide. He petitioned for a deferred prosecution. He went through some treatment on that, not without relapse. And he received approximately, and when it was revoked because of a subsequent assault domestic violence charge, he was sentenced to 6 months in jail. And then when he received this DUI, he was sentenced to the additional 6 months in jail. So he served a total of a year on the prior DUI charge. So I was tasked with defending this case as a private attorney. On several occasions, Mr. Rogerson and I have sat down to talk about his life, the experiences he's been through, the impacts it's left on others. And what my law partner and I decided to do was to really try to convince and appeal to Mr. Rogerson in a way that allowed him to open up, feel safe in opening up, understand that he was not going to be prejudged for his behavior, and give him an opportunity to become vulnerable and explore options to change his life. So what's happened since the 2019 date when this court first saw Mr. Rogerson? He's gainfully employed. We got him into treatment with Sarah Workala, and Your Honor will have the opportunity and has the copy of his evaluation or her evaluation in front of you. What you will see in that evaluation is that Mr. Rogerson admits to making a very bad choice on the date in question. He admits to drinking and getting behind the wheel. There is question, and I will not go so far here as to say that the events that were, or the vehicle that was seen racing around the streets that day was in fact Mr. Rogerson. There is no denying that when he was contacted by the officer that he had been drinking and he did move a vehicle. The question here is whether or not the vehicle seen previous was him. That's a question for a different day. There's certainly no legal challenge here to the righteousness of the stop and the subsequent investigation. And Ms. Dew brings up a very good point. How do we change behavior? How do we assure ourselves that Mr. Rogerson is not going to cause another family grief or harm? I think we change behavior with love, as corny as that may sound. We worked pretty hard with Ms. Workala. We've gotten Mr. Rogerson involved with her. When I spoke with Ms. Workala on multiple occasions regarding Mr. Rogerson's case, my concern here was we have a history of DUI. We have a history of failed treatment. Tell me what's going on. Let's do a deep dive into Mr. Rogerson's life and find out, where does this stem from? I have a family that is a family of addicts. I have an uncle who is an alcoholic. I have a cousin who's a recovered heroin addict. I have a nephew who's a heroin addict. I have a niece who's a nephew addict, or who's an addict. I understand how hard it is to quit, and I understand what it takes for a family to push someone to do that. And the choice has to be personal. Ms. Workala, in looking at Mr. Rogerson's life, has determined that there's a lot of untreated material going on, untreated trauma in Mr. Rogerson's life before DUIs that certainly could have set him on a path to lead him to where he's at. And although a deferred prosecution treats for addiction, it doesn't necessarily treat for any mental health issues that are going on or any past traumas. So our hope here is with Ms. Workala's plan and his involvement with that plan, that we can address some of those things that have been left unsaid and untreated. So with respect to the recommendation of the prosecution in this case, we're hopeful that the court would consider either lightening the 30-day sentence to make sure that he's allowed to treat. Mr. Rogerson is gainfully employed. He takes care of vacation homes out in the Westport Grayland area. It's his only means of income, and it's his only way to pay for the treatment that obviously he's going to need. Because even if the court chose to put him in jail for the full 365 days, we all know, unfortunately, at the end of the 365-day term, he's going to get out. So we kind of have to look at, how do we address the situation when he gets out? He's essentially been on probation, if you will, with the court since September of 2019, had an ignition interlock device installed on his vehicle. He has not had any failures. I think that's also important for the court to take note of. We had him complete the DUI Victims Impact Panel. We filed with the court the income declaration just to simply show what his ability to pay legal financial obligations are. Certainly not asking the court to reduce the fine, but take that into consideration when considering whether or not to impose things such as scram or electronic home monitoring, both of which can cost upwards of $1,000 to $2,000. Certainly, we want to be able to keep Mr. Rogerson employed. So if the court it does impose jail time, what I'd ask you to do is to consider the possibility of allowing him to do that in increments. We understand that's another financial burden he'll have to ferry. But when faced with being able to earn an income to pay for his treatment, I think it's important that we keep him on that path so we don't lose the focus of that 12 months of treatment. I can't sit here and tell you, Your Honor, we're going to come out the other side of this and not have any further violations. That's certainly the hope. That's certainly the conversation we've had, Mr. Rogerson. And that's our plan. And I feel like maybe for the first time in Mr. Rogerson's life, he has some sense of where he's headed. So for those reasons, we ask you to consider a reduced sentence or incremental sentence of jail times imposed, and to consider the financial impacts of what scram or electronic home monitoring would do in this situation, just in respect to his income.
How much longer will he be participating in treatment?
He will have an additional 9 months of treatment, beyond which, in my conversations with Ms. Workala, she hopes that he sticks with her to come back to him for any subsequent matters that may come up during the course of his first course of treatment.
Okay. Mr. Rogerson, before I sentence you today, you have a right to make a statement to the court. Is there anything you'd like to say?
Yes, Your Honor. Your Honor, I know that you've probably heard it all with people apologizing and lying to you, but I can assure you I am different. I have learned my lesson. I have made many changes already, and I will continue to do so. I know I've made some big mistakes over the years. I've also learned a lot. I'm ashamed of my bad, irresponsible behavior. I have a plan and goals in place to ensure my success. I have a large support group in my corner, including my wife and counselor and work associates and church friends and family that I am in constant communication with daily and that keep me accountable each day. I will prove to my children and other people's children that people can make great changes in their life with hard work and help. Thank you for your time, Your Honor.
Well, this is an agreed recommendation. I've reviewed case history. I've reviewed the treatment assessment and the information provided by counsel. I'm going to follow the recommendation of the parties. I'm going to I'll allow the jail time to be converted to the 30 days of scram. And it's the court's order that in addition to his required ignition interlock through DOL, with the scram, he will have that for 180 days, and that 180 days begins Friday, with proof filed no later than 5 o'clock Friday of the scram device. And I'm going to reserve the additional period of scram that's recommended in here because we're going to have Mr. Rogerson on court probation for the next 24 months, and we're going to schedule in-person review hearings so we can stay on top of treatment compliance, stay on top of the community restitution hours that I'm going to impose, and make sure that we keep him on track, because if he steps 1 inch offline, I've got a suspended sentence and I will reserve making a decision on the remainder of the scram and what to do with that as we move along. I also want treatment reports filed on a timely basis once a month with the court. I'm imposing total fines and costs of $1,000, $1,245. Is this recommendation for the 240 hours of community service, is that a suggestion to convert that, or is that community service hours as part of a sentence, not related to any sort of conversion? What can the parties tell me?
It's the city's intent that that be not in addition to the sentence.
And
That was our understanding, Your Honor.
that's what I assumed it was. I just wanted to clarify because I am going to impose the 240 hours of community service, and he's going to continue and complete his mental health alcohol treatment that he's going through right now. And so with that sentence imposed, let's go ahead and set a review date 3 months from now. Madam Clerk, what do we have?
Date. That would put us April 14.
Let me take a look at my calendar.
Your Honor, I can tell you I will be in day 2 of a 2-day trial in Superior Court. So if there's, I certainly, my intention here is to stay involved with this particular case to make sure Mr. Rogerson carries through. So if the court can do the 21st, that would work better.
The 21st, if we do that, we would have to promptly start at 12:30 because I will be prosecuting at 1:30 in Ocean Shores and I need to have drive time. So let's set it on for a review hearing on April 21st. We'll set that first on the docket. Again, I want treatment reports filed monthly, no excuses that the treatment provider's not getting them or they weren't faxed on time, the normal excuses that the court's used to hearing. We're not going to play that game with this case.
Got it. You're on the scram by Friday. I understand the court's concern. We've worked with Scram before. We've worked with many clients on Scram. Can I ask the court just to get us until next Tuesday, potentially? Scram typically comes for us, if I recall correctly, Vancouver or Tacoma. And so we have had some scheduling issues with them with COVID.
So they have to physically come up to Pacific County rather than him going to Chehalis, Centralia, Olympia to have that installed?
My understanding is they physically come to the person.
Okay. 5 o'clock by Tuesday. Proof of installation.
Okay.
So Mr. Rogerson, I just want to make you aware you have 334 days hanging over your head if you step out of line.
Yes, Your Honor. I understand.
Your Honor, what's the timeline for completion of community service hours?
With the 240 hours, how many hours a week do you work your job, Mr. Rogerson?
It can be a variety, a lot of drive times, sometimes from just back and different properties, sometimes the same. It just really varies depending on business, but it could be anywhere from 20 to 40, 50, you know, guess, what's the question again? Sorry.
I'm just trying to figure out your work schedule and how that plays into time for community service. Let me ask you this, Mr. Needham, is there a nonprofit agency that's already been contacted to address this with?
There hasn't, Your Honor, and part of the issue that we run into is COVID. So it's not a problem per se of finding a nonprofit. It's a problem per se of finding a nonprofit in the midst of working with others on a volunteer basis.
Good. I know food banks need a lot of help right
Sure.
now. That might be an option.
Does the court want to set a tentative to be completed by or a drop dead date, say within the first 12 months? And let's see at the first review hearing how we're doing on that.
No, I'm gonna say I'd like at least 10 hours a month.
Okay.
And we can check that come our 3rd month review.
Do that.
Okay. I think I have covered everything. Madam Clerk, if you would put my sentence to written form, if you give me the judgment and sentence, I'll review it, make any changes that need to be made, sign that, and the parties can circulate for signature.
There was one other matter, and that was there was an associated, I believe, traffic infraction that went with this.
Action was involved, yes.
And Mr. Kelly or Mr. Duncanson and I had talked about that, and I believe the city's position was to dismiss it pursuant to the plea.
Okay.
That is true.
See that in the report. So does the city have a motion?
Yeah, city would move to dismiss the trailing infraction.
The fail to stop or yield at intersection on the city's motion to dismiss is granted. And I think that concludes sentencing today for this matter.
Believe so.
Mr. Needham, are you here on any other matters, or is this your only case?
The only case I have on today for this court.
Okay. Then with conclusion of sentencing, we'll move on to the remainder of the docket that I'm here as a pro tem for.
And if the court clerk just wants to email me the judgment and sentence, I'll get it over to Mr. Rogerson for signature. Thank you.
Thank you, Your Honor.
We have a review hearing for Richard Meyer. Is Mr. Meyer here?
He is.
Hello?
Hello?
All right. Is this Mr. Richard Meyer that we're speaking with?
Yes, you are. Thank you.
Okay, Mr. Meyer, your attorney, Mr. Quittner, is present today. This comes on for a review hearing. What can the parties tell me about this?
Well, Your Honor, this has been, we've been monitoring Mr. Myers' compliance for quite a long time. He had run into a problem with the treatment facility that they would consider marijuana use to be a violation of the program. And ultimately, I subpoenaed records, which I believe I've forwarded to the court now, from Lifeline that show their report to their dealings with Mr. Meyer. They haven't been responsive to my follow-up phone calls, but what those reports appear to show us is that they do at least regard marijuana use as something that would eliminate him from their program. They sort of only allude to it. Mr. Meyer is long on record as having a medical usage, a medical card for it. And since Your Honor had indicated that the court might be willing, now that we have done this for almost a year, to relieve Mr. Meyer of further obligations if the court had a chance to see those records from Lifeline, I am asking today that the court do that. I think that he's clearly not drinking and he's on top of that, and he's done everything he can humanly do to cooperate with the orders that he's subject to.
Judge, before you, I just want to say that at this point, I'm actually in agreement with that. Mr. Myers has done what he can. He hasn't been drinking, and at this point, we just feel like it's been going on for too long, and we're not really concerned about public safety at this point.
Okay, and this was not a marijuana DUI, correct?
Nope.
No.
Well, I'm inclined, given everything I've heard and know about this case over the past few months, I'm going to release Mr. Meyer from the obligation of further treatment. We will indicate in docket entries that treatment is hereby terminated. I will, Mr. Meyer, warn you that although it sounds like you've got the alcohol use under control, a person can still be cited for DUI while being under the influence of marijuana. So I do want to caution you with that.
Yes, Your Honor, I understand that.
Is there anything else to review? Fine, or are we doing okay on fine payments?
He's behind a little bit.
How far behind?
I would have to look it up.
Oh, I can tell you. It's just $740, and it'll be. I sold off some equipment that is going to be picked up on the 20th, so that will be paid off here by the end of the month, the entire amount.
That's what we like to hear, Mr. Meyer, because without being required to pay for any further treatment, we should have funds available to pay that fine in full.
Yeah, I sold off some tools, and they're being picked up on the 20th, so there's funds to cover that.
Okay, well, we'll look for you to catch up on those fines. And how much longer do we have Mr. Meyer on probation?
For 5 years total, right? So another 4 years.
Yeah, and this is a 2017 case, so he's got another year left.
Okay. Well, Mr. Meyer, assuming you catch up on your payments and you don't hit any bumps in the road, we will not be calling you back into court.
Oh, I appreciate that. It's all set in motion, so we'll close the door on this one.
Okay, well, that concludes your hearing today, and good luck.
Thank you, Your Honor. It's been quite an experience. You guys are honorable people, and I appreciate the where apathy is a solution. You guys went well beyond that. Thanks to the prosecutor on that also. And John, you're a star.
Thanks.
Take care.
Bye, Mr. Meyer. And then the next case is Avi. I butchered this last name so many times. Mr. Penoyer, how do we pronounce this last name?
I believe it's Parmesan.
Amachon. Is he present today?
He is.
And have we brought him in yet?
I see him there at the bottom.
All right, is Mr. Palmachon present? That would be V's Samsung.
Yeah, that's him.
All right. Mr. Palmachon, can you please identify yourself for the record? All right, let's put him back in the waiting room while he figures out how to use his phone. And we'll move on to, I believe it is Edward Taylor.
That one's Killian's. I think. Well, yeah, he's up. There we go.
I do not show him in the waiting room.
We have a warrant out still, do we not?
We do.
Okay, well, we'll just wait until that warrant's executed, I suppose. And we also have Seth Tibbetts.
On today?
Don't see his number on here or his name.
Hey, Mr. Whitner, have you had any contact with your client?
I have, and I didn't prepare for a hearing today, but it seems as though he's in treatment. He's in the new state. He's in Colorado, and last I heard, he was in compliance.
Should we reset this matter then? Okay. The case will be reset to next month.
Okay.
And let's give Mr. Palmachon one more try. And if he can't figure his phone out, we're going to have to reset his case. The court is calling for Pavi Palmachon. We have a V Samsung that appears to be connected by audio, but we're not hearing anything. So, Mr. Palmachon, if that is you, we're going to set this matter over a month, and you need to figure your phone out because the court's not going to be held hostage due to your technological inability. So we will set that case over, I think, to the 21st. Or no, not the 21st. I'm thinking of, let's just set it over to next month and send me the court date.
Okay.
Okay.
It'll be the 10th.
Okay. Well, with that said, I'm going to head out.
Thank you, Mr. Bates, as always. We appreciate it.
Thank you.
That's Judge Bates to you, Judge Kenoyer.
I'm sorry.
All right.
Apologies, Your Honor.
Okay. Bye.
No, I walked right into that one, didn't I?
Yes, you did. So we lost the jail. They couldn't wait any longer.
That's too bad.
So we'll have to reset Mr. Martin's case.
Is this one where actually, I guess I should figure out where we're going on this one because, if he's in custody, we have the quicker speedy trial. So without getting into the details too much here or anything, have the parties talked about this case at all?
I don't think so.
Is he being held on
Oh, you
Drug
know what?
charges, or is he being held on spirit?
You're probably right, Mr. Duncan. I misspoke. That's probably true. He's probably not being held on our matter.
He is not. He's
I don't
being
know
held on superior charges.
I certainly haven't ordered anybody to be held on my matter, so. Good point. Obviously, I'm off track today, so.
I would ask if it's all the same to the court and the participants that we call Mr. Janae next. I keep getting messages from him that his phone is about to die. And he's been in that for an hour, so I hope we don't lose him.
That is fine with the court.
Is he by any chance calling from a different phone? Oh, there he is. Okay, sorry. I missed him.
Mr. Janae, can you hear me?
Yeah, I can hear you. What's up?
Great. Well, what's up is we are here today for a pre-trial in South Bend Municipal Court for your case. So I'm now going to ask your attorney where we're at on the case.
Your Honor, we've got it resolved. It's he's pleading to the charge, which is disorderly for setting off some fireworks within the city limits. Prosecutor was right reasonable about a penalty, which I believe was a fine of 100, was it 150? In any case, we have agreed to resolve it. Mr. Janae has the pleadings. I don't have those for the prosecutor or the court, and I'm asking Jordy to get them to me or to the court. But we will enter a plea, and we'll just let the court know that we have a joint recommendation on sentence.
Okay. Well, so real quick, where are we on speedy trial on this case?
I think we recently waived.
I think you may have, but I'm just, my
I'm
job.
pretty sure I waived.
On 120, he was an FTA, so
Okay,
does that reset it?
yes.
So we would have till April.
When do we want to come back on this, just the next docket?
We could do that.
Mr. Janae, are you available on our next docket, which would be February 24th?
Oh, I'm actually not available on that day. I have a trial in Superior Court.
Okay, how about March 10th?
Works for me.
Mr. Whitner, are you available March 10th?
Yes, I am. And Jordy, I'll send you traditional reminders.
Very cool.
Okay, unless there's anything else, we can let Mr. Janae go. All right, hearing nothing, you're off the hook, Mr. Janae. Thank you. I guess we should make note that if Mr. Whitner is not available for the next docket on the 24th, we may not be able to get much done. I mean, we can do arraignments, you know. I'm just making sure the clerk knows that.
She asked me about it earlier today, so I think she knows.
Fair enough. All right, who do you guys want to call next?
Can we reset Donald Martin to March 10? Will that work?
As opposed to the 24th?
Yes.
All right, because John won't be available. Yeah, that's fine.
Okay. You want to start with your mitigation hearings from last time that didn't work?
Is that what those are?
I'm sorry, I didn't hear you.
Okay, those are the ones from last time.
Yeah.
I can't recall. Yeah, let me grab those two files.
Okay.
That's that. Okay, I've got them.
Hello.
I recognize Mr. Radka last time.
Can you guys hear me this time?
We can. This is a very exciting technological innovation happening here, Mr. Radka.
Woo-hoo. Okay, no more being silent.
This is exciting. Okay, so you are here today for a mitigation hearing. What that means is that you admit you committed the crime, but you would ask the court to take some factors into consideration and maybe give you a break on the fine. Is that correct?
Yes.
Okay. You basically, it says here that you are wheels off road from what day is that from? 10/28, 2020. It says you fell asleep and went into the ditch. You didn't ram into anybody, and the cops gave you a break even though you didn't have insurance. That's all I've got on my report.
I do have insurance now.
Okay, that's good to hear.
So I got that taken care of.
Okay.
I was driving home from work. We had a late day. And I knew I was getting tired when I hit South Bend. And I knew the park was at the other end of South Bend. And I was going to pull in there and I was going to take a nap. And I was about 50 yards from where I was going to park and pull over. And I just didn't quite make it.
Which direction are you driving?
I was heading north back to Aberdeen. I work at Goose Point Oysters.
Oh, okay. So you're driving home.
Yeah, I was heading home.
Heading home. Okay. And just looking here. You don't have a horrible driving history. You got nothing since 2017 anyway.
Yeah, I've been trying to be very, very good.
So I have some limitation on how much of a break I can give on these, on speeding, on these kind of tickets, simply because most of the money off the top goes to the state and none to the city. So I can't usually go below like 90, 95 bucks. But I'm willing to reduce the fine to that amount.
Oh, thank you.
So I'll reduce it to 90. You know, this is the kind of thing that obviously could happen to anybody. I appreciate that you're going to be more cautious in the future, I'm sure. And my only question for you is where Bear Gulch Road is. I've never heard of that.
It's actually on the other side of Wishkah. Instead of going out toward Wishkah Road, it's on the west Wishkah side.
Yep.
It's right past Fern Hill Cemetery in Aberdeen.
Yep. Oh, it's back up there. Okay. Yeah, I know where that is. Okay. So $90 fine imposed.
Is there a possibility of making payments on that? Like maybe 2 increments?
I'll send out a notice to you, and when you get the notice, it'll give you a due date when you need to contact the court by if you want to set up payments.
Okay, thank you.
Okay.
All right. Thank you, Mr. Radka. I appreciate it.
Thank you.
Great day.
Yep. Bye.
Bye.
I have a whole bunch of new numbers on here that I do not recognize.
That makes it hard.
It does. It does. I have Jeff Arnold on for, I believe it was Steve Smith, right? Yes. Unfortunately, I have no idea which number is Steve Smith's. And there's probably more than a dozen numbers on here that I don't recognize.
If we have to just call people in, we'll call people in. I just get her done.
Okay.
I don't really care.
So I believe this is going to be Tony Swanson. And that is a guess. On for arraignment.
Okay, sir, can you hear me? Can you hear me? I've got two people looking at me, adjusting the camera, but they don't appear to be responding to what I'm saying. Who do you think this is?
I believe it's Tony Swanson.
Okay. Is this Tony Swanson? Yeah, I don't. They just keep moving the phone around, but I'm not hearing any sound.
Go back in the
Right.
waiting room.
Yeah, we can't hear you guys. You need to figure out how to make your sound work. And then we'll take your case, okay? We can't hear you. Yeah, okay.
Okay. I was hoping to get Mr. Nunez on, but I don't see his number on here. We got Pete waiting. I don't see either of the Hispanic cases on right now.
Okay.
Ms. Ballesteros either?
Pardon me?
There's a Ms. Ballesteros, she's not on there either?
Not with the same number she had last time.
Okay.
So we'll just start taking them down the line,
That's all I can think to do.
find out who they are as we pull them in.
Okay.
Primusburger,
Be a good one.
he's on for pretrial.
Yep, I've got paperwork on it.
Okay, I can hear you guys now.
Great. Hello, Mr. Prinesberger.
What's that?
I said hello.
Hi.
Okay, so Mr. Prinesberger is on today for a pretrial on his case in South Bend. I received paperwork prior to court today from one of the attorneys. And it looks to me like there's an agreement here. It looks like the charge of failure to transfer title is going to be amended to an infraction with a $231 fine. No insurance ticket is going to be dismissed. And it looks like the defendant's going to, I guess I got an order amending and an order. Regardless, the net result.
There's two, essentially the no insurance will be dismissed. The failure to transfer title will be amended. And then he's answering committed to the other failure to renew. So there's going to be two failure to renews.
So writ large, the fine will be $462 to two infractions.
Yes.
Okay. All right. Mr. Prinesberger, is that your understanding of what was going on?
Yes, sir.
Okay. Well, I don't need to take a plea or anything here. This seems reasonable to me and within the interest of justice. Mr. Quitner, do you have anything to add?
No, that's a good summation of what we came up with. I think he did a really good job of getting on top of things. He was forthcoming and what's the word I'm looking for? Well, he was forthcoming, almost to a fault from the perspective of a defense attorney. But this is a good result, and he's done everything that he's supposed to do. So we're just lucky to get this behind him.
All right, Mr. Prinesberger, you'll be able to make those payments?
Yes, sir. Do just take it down to City Hall?
Yep.
Perfect.
Yep. And I think you'll be getting mailed information on how to make payments too in the mail.
All right. Well, I'm just going to try to take care of it as soon as I can.
Makes sense to me. Okay, I don't have anything further on this bit. Thank you guys for getting this.
Awesome. Thank you.
All right.
Okay.
All right. I see a crooked view of something.
Says it's connecting to audio.
I've noticed sometimes these look almost like art photography of some kind, you know, when they first start. They're so abstract.
Okay, we'll put him back in the waiting room, and
Yeah, whoever that is.
I've got Miss Carrie Ann Williams
Okay.
is there, and I can identify her, so.
I don't even know what that's on for.
Music time, serious. We've got to explain exactly how.
That's definitely her.
Is that a television program or something? Miss Williams, can you hear me?
I can.
Okay. This is Will Penoyer. I'm the judge for the city of South Bend. And we have your case on here today for a pretrial. You can hear me okay?
I can, yes.
Great. So now I'm going to move over to your attorney. Mr. Whitner, what are we doing?
Well, Your Honor, we've got a resolution on this one too. Ms. Williams has got her license back. She's got a valid license, and so we're asking the city to amend the charge to no valid operator's license second and impose a $250 fine. That's agreed. I actually have been doing a disturbing amount of last-minute sending of pleadings over to Mr. Duncanson, but that one for some reason has not made itself available to me. It's the problem with syncing my assistant and I, but that pleading is ready. It just needs signatures, and we're asking the court to amend the charge given the proof of her license.
All right. So, Ms. Williams, did you understand what your attorney just said?
Yes.
Or sort of?
Yeah, I understand. Yeah.
Okay, so what's happening here, I'm just going to state it again. My understanding is that you got your license. Congratulations. That's great. That's what we actually would prefer rather than to punish people. So now that you've done that, the city is going to amend the charge to an infraction instead of a criminal charge. And then you will just need to pay whatever the fine. What did you guys have an agreed fine?
What's that?
I'm just checking on the fine, Miss Williams. But they
$250.
What?
$250.
250. Mr. Duncanson.
Yes, 250.
Okay. How quickly when did Miss Williams get her license back?
About 3 or 4 months since she got the charge.
What's that?
Did you say how quickly?
Yeah. When did she get her license back?
When did she get it? No, I've got it in front of me.
Williams, do you remember when you got your license back?
I got it in December, like as right after I got pulled over, because I didn't know I didn't have one, but I got it in December.
Okay. Did you have a ticket somewhere else you had to deal with or something?
Yeah, I had one, an old one that I had forgotten about, and so but I got it right away. I just had to go and renew it.
Oh, okay. All right. Well, I'm gonna, on this one, just because you got it so quickly, I'm gonna reduce the fine to 150. And,
Thank you.
No problem. Good job getting it taken care of. When the order is presented to me, I will sign it.
Okay.
Okay.
Thank you so much.
No problem. Have a great day.
You too. Thank you, Jonathan.
Thank you.
Okay. Moving on to the next one. This is another one.
With what? What?
Yes, sir. Hello.
Hello.
Hi.
Hello. Hi, this is Stephen Smith.
Okay,
Hello,
let me,
Hello,
let
Mr.
me,
Smith.
sorry.
My name is Will Pinter. I am the judge for the city of South Bend. And your case is on for today for pre-trial. We're just getting your attorney on the line.
He's gone.
Hello? Hello?
Mr. Smith, can you hear me?
Yes, I can hear you.
Okay. Well, we're just waiting. Your attorney, we're just trying to get your attorney on the phone, okay?
Okay, thank you.
So, he's not on right now, Madam Clerk?
No, he must have had to leave.
Mr. Smith, we're gonna have to call you back in a few minutes, okay? When we get your
Okay,
attorney.
this is at the community action. I'm using their phone.
Oh, okay. No, well, I understand. You just hang tight there for a little bit, okay?
Okay,
Thank you, sir. We'll get
thank
back.
you.
Thank you.
Okay, bye. They're on the line?
Okay, next one.
That's one, isn't it?
Hello?
Hello.
Hello?
Hi, this is Will Penoyer. Who is this?
This is David Bennett.
Oh, hi, Mr. Bennett. My name is Will Penoyer. I'm the judge for the city of South Bend.
Yes.
You're doing court today. Your name is Bennett
Yes.
with a B?
Bennett.
Okay, just looking for you on my calendar here, sir.
Should be at the top of page 3.
Page 3. Oh, okay, it's on for arraignment. Okay. Sorry, Mr. Bennett, I'm just trying to find you here. You are charged. You're charged with driving while license suspended in third degree criminal charge, and then you also have an infraction for driving without insurance. So today is just your arraignment, sir. I'm just going to read you your rights and see if we need to appoint you an attorney, and then we'll set another court date, okay?
Okay.
All right, so DWLS 3, driving while license suspended third degree, is a standard misdemeanor, which means that the maximum penalty is a $1,000 fine and 90 days in jail. That's not standard or even normal. That's just the maximum possible under the law. Okay?
Okay.
So, you have the right to remain silent. You don't have to say anything about the offense. You have the right to be defended by a lawyer and have a lawyer present at all hearings. You can hire an attorney, but if you can't afford one, we will appoint one for you. You also have the right to have your guilt decided by a jury. A jury trial begins with you being presumed innocent. You have to be proven guilty at the trial beyond a reasonable doubt. You have the right to be present when evidence is presented to the jury, so you can see, hear, and question the witnesses called against you. You may call witnesses to testify for you at no expense to you. You can choose to testify, but you don't have to, and if you don't testify, that cannot be used against you. You have the right to a trial within 90 days of today, which is when you'll enter your plea. And if you're found guilty at trial, you can appeal your question of guilt to a higher court. If you were to plead to the charge, however, you would waive your right to appeal. I've reviewed the police reports and I found there's probable cause for the case to go forward. That does not mean I found you guilty. It just means that there's enough facts in the police report to allow the case to move forward. Sir, do you understand what you're charged with and what the maximum penalty is?
Yes.
Okay. So at this point, what were you wanting to do about an attorney?
At this point, I don't know what to do because I never knew I had a suspended license.
Okay. Well, sir,
there was no notice, no nothing.
Sure. Well, sir, I'm going to encourage you. Hold on. Can you please wait for a second? Don't say anything more about the case and that, because I don't want that to be held against you in court. What I think.
Okay.
Can you afford an attorney, sir?
No, I can't.
What's your monthly income?
My monthly income?
Yep.
0.
Okay. Well, that makes it simple enough. So how about I appoint a public defender to represent you, sir? That sound okay?
Okay.
Okay. I'm going to appoint John Quinton as our public defender for the court, and we're going to give you his contact information. You can give him a call and let him know your situation. Tell him what you were telling the court, and you can talk with the prosecutor and try to figure out what's going on with your case, okay?
Okay, and who am I supposed to speak with?
His name is John Quitner. We're going to send you his contact info, but if you have a pen, I can give you the info now.
Okay, I got a pen and paper right in front of me.
All right, his name is John, and the last name is
Don?
Yep. His last name is spelled Quittner. And Mr. Quitner's phone number is 360-642.
Okay, 360.
642.
642?
Yep.
Okay.
3139.
3139?
You got it. And don't call him today because he'll be in court with us.
Okay, so when am I supposed to call him then?
Well, you can call him tomorrow, Friday, next week.
Okay.
And so we just need to set your next court date, sir. And
Okay.
we'll put you on for March 10th for a pretrial.
March 10th?
Yes. Same time, 12:45.
12:45?
Yes, sir. Just like you did today.
Okay.
And you talk to Mr. Quitner, give him a call tomorrow. If nothing else, leave him a message. I know he'll get back to you, and you guys can figure out what you're going to do, okay?
Okay.
All right. I appreciate you calling in, sir, and we will see you on the 10th.
All right. Thank you.
Have a great day.
You too.
Okay.
Okay, Mr. Arnold's back. Do
Okay.
Mr. Smith's case quick. Oh, we've got him.
Hello.
Mr. Smith, are you there?
Yes, sir.
Great. Your attorney is just connecting now to the thing, and then we'll be ready to go.
Okay.
We're still waiting, Mr. Smith. His computer.
Okay. Okay.
I just shot Jeff an email, so.
Yeah. It looks like he's on a phone. There he is. Jeff, can you hear me?
I can. How are you, Judge?
Good. How you doing, other
Good.
judge?
Good.
So, Jeff, we've got Steve Smith's case on.
Yes.
Do we know what we're doing on this case?
Well, Your Honor, I don't have any communication with Mr. Smith because I don't have any contact info via discovery. So if he's on, what I'd like to do is just get a way to be able to chat with him about this case.
Sure.
And then, so I'd ask for a continuance. I think till the next hearing is fine. I just need to communicate with Mr. Smith.
That's fine. Mr. Smith, what's the best way for Mr. Arnold to get a hold of you?
Community action, you can get me home here. This is the only phone I got.
Community action?
Yeah, the community action program. I'm using their phone right now.
Okay, how often are you there, sir?
I can be here anytime he needs to talk to me.
Okay, Jeff, do you want to, I guess, why don't we set a time now while we're on so that while you guys are both in the same place.
Not
Okay.
a problem, Your Honor. So, Mr. Smith, does tomorrow or Friday work for you, sir?
Okay, tomorrow works perfectly for me.
Okay, do you want to do tomorrow afternoon?
Okay.
Do you want to say 2:30, 3 o'clock, somewhere in that range?
Okay, sounds good.
Okay, so 2:30 or 3, Mr. Smith?
No, how about the 2:30? 2:30 will work.
Sounds good.
Okay, Mr. Smith, can you give Mr. Arnold the number he would call there, and I guess vice versa?
Okay.
What number is it? It was at 875-8805.
Yeah, I think so.
That's what it looks like on my screen anyway.
Yeah, I think so.
Do you see that, Jeff?
I do. I have it written down, Your Honor.
Okay, and can you give him your number?
Mr. Smith, do you want to be able to write it down? Do you have a pen or
No,
pencil?
hold on, sir. Hold on, sir. Okay. What is
It's
it?
360
Okay.
591
591. Okay.
6249.
49. Okay.
Okay, great. I'm glad you guys were able to make contact. We'll continue this on to February 24th, and we'll get involved then.
Okay, thank you.
224 at 1 o'clock, Judge?
Yeah, 1 o'clock's fine.
Okay.
Okay.
Did you hear that, Mr. Smith?
Yeah, 1 o'clock. Yep.
Okay.
February 24th, Mr. Smith.
Okay.
Okay, thank you guys.
Thank you.
Appreciate it.
Okay, guys. I'll see you tomorrow.
Jeff, you don't have anything else, do you?
No, that was my only matter. And Judge, I apologize. I tried to log in multiple times and I don't know what was going on.
Well,
with the Zoom. I apologize.
I have no doubt that you made your best effort. I'm not worried about it.
I tried. All right.
So I'm not worried about it. I appreciate you helping out, Mr. Arnold.
Thank you. Have a good day.
Okay.
Just got appointed judge in Cosmopolis. We were in judicial training together just last week.
Oh, wow. Bring in our next one.
Hello?
Hello,
Hi, this is Will Canoyer, judge from South Bend Municipal Court. Who is this?
Whitley Stiegel.
Hi, how are you, Ms. Spiegel?
Good, how are you?
Great. I've got you on here today for an arraignment in the South Bend Municipal Court. So all I'm gonna do today is read you your rights and see if you need to have an attorney appointed for you, okay?
Okay.
Great. You are charged with driving while license suspended in the 3rd degree. That is a standard misdemeanor, meaning that the maximum penalty is a $1,000 fine and then 90 days in jail. That's the maximum. I've never seen anybody get that penalty for driving while license suspended 3rd. I'm just telling you because I have to read you the max, okay?
Okay, okay.
You've also got an infraction for defective exhaust, but that's not.
Yes.
So I'm just going to go through your rights now. You have the right to remain silent. You don't have to say anything about the offense today or in the future. If you choose not to testify at a trial, that can't be used against you. And the court would tell the jury that that couldn't be used against you. You have the right to be defended by a lawyer and have a lawyer present at your hearings. If you cannot afford an attorney, we would review your financial status and most likely appoint you one. You have the right to have your guilt decided by a jury with the presumption of innocence, and the prosecutor has to prove you guilty beyond a reasonable doubt. You have the right to be present when evidence is presented against you to the jury, and you have the right to present evidence to the jury. And if that costs money, you don't have to pay for that if you need to get a witness in to testify for you. You have the trial within 90 days since you're not in jail. If you're found guilty at trial, you can appeal the question of guilt to the appeals court, but if you plead guilty, you will lose most of your rights to appeal. I've reviewed the police reports and I've found that there's probable cause to charge you with driving while license suspended 3rd. That doesn't mean that I'm finding you guilty. It just means that there's enough in the police report to support the charges. Do you understand what you're charged with and what the maximum penalty is?
Yes.
Great. And what do you want to do about an attorney?
Sorry, what was that?
What did you want to do about getting an attorney?
I can't afford one.
Okay. Can you tell the court what your monthly income is?
I'm on state TANF, so I bring in $575 a month. I'm a single mom of 2 young kids.
Okay. If you're on state aid, then we treat that as qualifying for a public defender. So
Okay.
we are going to appoint John Quittner as your attorney. We will send
Okay.
you his contact information so that you can talk to him about your case. I guess we should confirm your address with the court. Looks like, do you have a PO box?
Yes, I do.
Okay, what is that?
It's PO Box 1047, and it's here in South Bend.
Okay, Madam Clerk, I just wanted to make sure you had that.
Okay.
Okay, she is going to send you contact information for your attorney, and
Okay.
we are going to set this for the next date will be March 10th at the same time, okay?
Okay.
All right, so talk to your attorney, and he'll help you guide you through the process, okay?
Okay, thank you.
No problem. Have a great day.
You too.
Bye.
Bye.
Okay, I think I have identified Mr. Loza.
Okay.
We can bring him in.
Hello? Hello?
We're here, Salvador.
Hello?
Hello, is this Mr. Loza?
Yes, this is Salvador Loza.
Great. Was this an interpreter case?
No.
No? Okay, I thought she had said that earlier. I'm sorry. All right. What are we on for today for Mr. Loza's case, guys?
Well, Your Honor, we had agreed that this one would be dismissed. Neither of us could quite remember why we didn't get it done last time. I assume technical difficulty.
This was the case where he was alleged to have gone to the school.
Yes.
Yeah, I remember us talking about it, and I thought that the idea was that it was to be dismissed.
Well, luckily we all agree.
Well, I guess can someone send me an order and I'll sign it?
All right, thank you.
All right, Mr. Loza, I apologize for misunderstanding. This case is going to be dismissed.
All right, thank you.
Okay, have a good day.
Yep.
Okay. And I'm going to bring in a unknown number.
Look, I think there's a breakdown in communication or something, but I mean, if I got my own decks, I'll start doing that. But
Well, no. So
I'm just frustrated that we keep seeming to have this breakdown. You know, we're
hold on a
you
second.
understand I got 500 meetings to go to, half of them are non-value added, right?
Hold on.
We're trying to do
We're running court here.
It seems like every time we come to quality council, we're blue, yet we're still acting like we're totally upside down. And I'm just
one out.
frustrated. Okay. Anyway.
Hey, Ken.
I got to do something value added, so figure out my deck.
Hello?
Hello.
South Municipal Court. We're trying to run court here, and I'm hearing a bunch of noise in the background.
Well, so I'm at work and I've been on hold for like an hour and 20 minutes. So I was trying to multitask and I just happened to get a phone call while I was on hold with you guys. I've got 2 phones going right now. So I apologize.
That's fine. You don't need to apologize. I was just confused, sir. Can you tell me your name?
Michael Cheney.
Michael Cheney. Okay. You're on for a mitigation hearing today.
Yes.
Okay. So what that means, Mr. Cheney, is that as I understand it, that you admit you were speeding, but that you would like the court to consider some mitigating factors and maybe give you a break on the ticket.
Yeah. Well, at the very least, I have a clean driving record and I don't want my insurance going up because I've got a ticket on my right. This will be the first ticket I've had in like 20 something years, 15, 20 years. And so what happened was I was driving through South Bend and I'd gone through the town
And I was looking, and I knew I was exiting the town, and I was on 101. So I figured that the speed, there would be a speed increase coming up. So I started to increase my speed because I didn't see a sign, but I was well out of the town limits. And so as I was going down the road, there was this truck going in the opposite direction. All of a sudden his lights turned on, and I realized it was a cop, and I realized he probably had me over whatever the speed limit was. And so when he pulled me over, he basically said, "Hey, I got you going 10 over." And I'm like, "Well, yeah." I said, "I was looking for a speed limit sign." I said, "Because I left the town, but I didn't see one. And I was figuring there had to be one up here sooner or later, basically letting me know what the deal was." And he's like, "Well, there's one a way back, and it basically said it was 35. And I was like, "Well, I didn't see that one." And so he's like, "Well, it's back there." And I'm like, "Well, okay." So then he wrote up the ticket, and then I got in my car, and then I drove less than a tenth of a mile around this bend, and there was the sign for 55.
Right, sir.
Less than a quarter, yeah.
Well, you know what?
Yeah, that's all.
Well, okay. Well, you know, sometimes people often, you'd be surprised how often people don't tell me the truth about this sort of thing, but I can actually tell that you are telling the truth because I know, I recognize the location as to where you got pulled over, and that's consistent with what it's like there. It's right below my house, right below the cliff on my house. Not that it just means that I'm familiar with the areas.
Yeah, and I'm not, I admit that he got me, I was speeding up. I mean, but I was looking for the sign because I know I drive through the small towns and I know there's that transition. Yeah. And I'm not trying to get out of it. I admit what it was. And I even tried to go back and catch him, you know, to say, "Hey, you know, right around the bend." And I did, I clocked it. It was less than a tenth of a mile from where he had pulled me over before you went around the bend, because there were trees around the corner. And as soon as you round the bend, there was the sign. And I mean, the sign that he was referring to, I don't even know how far back that was, you know? And so, you know, I throw myself at the mercy of your court is the way I would put it.
Sir, I appreciate your honesty. You don't have much of a driving history at all. This, you know, one option you have, have you done a deferral before?
No.
You're allowed to do one every 7 years. And what that means is that if you do the deferral, it just means that you pay the fine. Granted, you have to pay the full price, but but then it goes off your record if you don't have any further traffic issues. I think it's over a year. Is that right, Madam Clerk?
Correct.
You follow what I'm saying?
Yeah.
So would you, well, what I guess I'm saying is I could either reduce the fine to $90, or if you wanted to try doing the deferral, you'd pay $139, and then if you don't have any violations for a year, it would be dismissed, and then it wouldn't be on your record.
No, I'd rather just pay the higher amount, not have it go on my record and be done with it, to be honest with you.
All right, so we're going to enter this then as the one-time deferral. Is that all right, Madam Clerk?
Correct.
Got that? Okay, and we'll send you information on how to pay it. And if you stay out of trouble for a year, as far as, you know, traffic stuff, then it will be dismissed at the end.
Okay. So you guys will just send me something in the mail to basically mail the payment back, or can I just call the courthouse and pay the fine?
They'll send you something in the mail.
Okay.
And you're at 17918 113th Street East, Bonnie Lake.
Yep.
Okay.
Yep.
All right, Madam Clerk.
Yep.
Anything else? We'll be good.
Nope, we're good.
Okay. Thank you.
Right, sir. Have a great day.
You too.
Thanks. All right.
Okay, next one.
Hello?
Hello?
Hi, this is South Bend Municipal Court.
Yeah, this is Christina Duncan.
I'm sorry, what's your last name?
Duncan?
Duncan. Christine Duncan, yes. You had a case in Raymond on Tuesday, right?
Yes.
Yep, I remember talking to you. Okay, well, this is Will Canoyer. I'm the judge for South Bend Municipal, and your case is on for a pre-trial today. Is Mr. Whitner on this one, or did she decline an attorney?
There's no attorney.
Yeah.
No attorney? Okay, Mr. Duncanson, have you spoke with Miss Duncan yet?
I have not.
Okay. My understand, I've spoken to Miss Duncan. I'm just thinking, Miss Duncan, do you want to have an attorney appointed for you on this?
No.
Okay. Well, Miss Duncan, you don't need to say anything for the record, but what I can tell you is it looks like you have a charge for driving without a valid license. And Mr. Duncanson, am I correct that if Miss Duncan were to come back to court in say a month with a clear license, she could have this reduced to an infraction?
Yeah.
Okay. And Miss Duncan, just for the record, the case in Raymond that I was the prosecutor appointed to, Mr. Duncanson is going to take over that case too, so he's aware of both of them. Okay.
All right.
So you know. So what I'm suggesting, if this is what you'd like to do, is come back. Would you like to come back in a month and you have your license in a month? Then we can get this dropped down to a non-criminal charge, get you a lower fine.
All right. Yeah.
Okay. Does that sound good?
Yes.
Okay. So, Mr. Duncanson, come back on March 10th. Does that sound okay to you?
Yep. This works for me.
Okay. That's it, Miss Duncan.
All righty.
March 10th, and you'll appear the same way by phone, and hopefully you'll have your Raymond matter sorted out that by then too, and we'll all be one clean thing. Okay.
All right. Thank you.
Thanks so much.
Bye.
Sorry, Mr. Duncanson. I don't know if that was confusing. That was the one I had asked you to take over in Raymond.
Yeah.
Yeah. Okay. Hello.
Hello.
Hi. This is Will Canoyer, judge for the city of South Bend. Who is this?
Hello.
What's your name, sir?
My name is Jason G. Pearson.
Jason Pearson?
Yes.
Okay. Great. Well, as I said, this is Will Canoyer, judge for the city of South Bend. You're on for a pretrial today in our court for failure to transfer title. Mr. Whitner, are you representing Mr. Pearson?
Yeah, I've been appointed to him. I don't believe we've made contact, have we, Mr. Pearson?
No, we haven't.
Okay. You guys haven't had a chance to talk yet then?
No, I'm afraid not.
No.
Haven't talked to
No.
No, I haven't talked to Mr. Duncanson about it yet either.
Okay, well, Mr. Pearson, do you have your lawyer's number?
Yeah, or somewhere I'd got to find it, but I don't have that right in front of me right now. I have all my other stuff, but.
Sure. Do you have a pen?
Yes, I do.
Okay, we'll give you John's number again, okay?
Okay.
Okay, you ready?
Sure am.
Okay, 360-642-3139.
3139.
Yep. And
okay.
John, this is your number, 995-2390.
Yes.
Okay, John, that's his number. So, John, what's a good time for him to call you?
We'll say tomorrow.
Give him a call. Okay, so give Mr. Whitner a call tomorrow, okay?
Okay.
All right, Mr. Pearson, what we're going to do is continue your case to March 10th because that's the next day Mr. Whitner's available, and give Mr. Whitner a call tomorrow, okay?
Okay. Well,
Right.
I mean, I'm sorry, Your Honor. I just, I don't want to waste anyone's time or nothing, but the last time I registered the vehicle and everything else, and he said it was still on the table for, or not still, but back then it would be amended. I don't understand what that meant, but I mean, I'm willing to, I want to take care of this as quick as possible.
Let's talk about it outside of
Okay.
court, okay?
All right,
Yeah,
sounds good.
sir, what I can tell you is that that's, what I can say just generically is that there's a good chance that if you have it cleared up, that you could probably get it amended to a non-criminal charge. And that's probably what I would talk to your lawyer about, but I can't say for sure. And I can't discuss it.
Okay, because I'm trying to get my CDL right now, and I just didn't want to screw it all up somehow, so.
Yep, just talk to him about that, okay?
Okay, I will.
Okay, thank you, sir. And we'll
All
see you at 10.
All right, thank you very much.
Thanks, bye.
All right, bye.
Okay. Hello?
Hello? Hello? Is someone there? This is Will Penoyer, judge for City of South Bend Municipal Court. Is someone there? All right. Not hearing any response.
Okay. Next.
Okay. So.
Hello?
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 Hello. Who is this?
Hi.
Who is this on the phone?
This is Babette Shine.
Babette Shine? Okay.
Yeah.
Great. Ms. Shine, this is Will Penoyer, judge for the City of South Bend.
I'm sorry, can you?
Okay. Are you able to
Yeah,
hear me
I can
okay?
hear you very well.
Can you hear me?
Yeah, I can hear you now.
Okay, this is Will Penoyer. I'm the judge for the City of South Bend Municipal Court.
Okay.
And you are on today for an arraignment for a charge of assault in the 4th degree.
Yeah.
Okay, so today at arraignment, what I'm going to do is simply tell you what you're charged with, read you your rights, and then see about getting you an attorney. And I'll also, I'll also most likely be entering a no contact order between you and the alleged victim in this case, which I believe is your mother.
Okay.
Okay. All right.
Okay.
So you are charged with assault in the 4th degree, domestic violence. That is a gross misdemeanor, which means that the maximum penalty in this case is a $5,000 fine and 364 days in jail. That's not what's likely to happen, but that's the maximum that could happen in your case.
Okay, I see.
You have the following rights: the right to remain silent. You don't have to say anything about the offense today or in the future. You have the right to not testify if this case goes to trial, and your silence cannot be held against you. You have the right to have a lawyer defend you. If you can't afford a lawyer, the court can appoint one for you. You have the right to have your guilt decided by a jury. A jury trial begins with you presumed innocent, and you're to be considered innocent until the prosecuting attorney proves your guilt beyond a reasonable doubt.
Okay.
Right to be present when evidence is presented to the jury and question witnesses against you. You can also call witnesses to testify for you at no expense to you. You have the right to a trial within 90 days of the day you enter your not guilty plea, which will be today. If you're found guilty at trial, you can appeal the question of guilt to the next court. If you were to plead guilty in this case, you would not. Your appeal rights would be much more limited. At this point, Ms. Shine, I've told you what you're charged with. I've reviewed the police reports, and I found that there's probable cause for the case to go forward. It just means that there's enough in the reports to maintain the charge. It does not mean that I'm actually finding you guilty.
Okay.
So, do you understand your rights that I've explained to you?
Yeah, I just missed the one part. You said something not guilty, and then I go to trial, and
and I'm considered guilty, what, then you said something after that.
I'm sorry. I'm just,
I thought you said, did you hear me?
I heard a part of what you said.
Oh, okay. So you said that if I went to trial and I was found guilty, that there was an option after that. I thought you had said
sure.
that. Is that correct?
Yeah, if you're found guilty, you have the right to appeal the finding of guilty to another court, to a higher court.
Oh, okay. I see.
But if you pled guilty,
Okay.
you agreed and pled guilty, then you don't have that same right to appeal. That's what I was telling you. So
yeah.
At this point, are you going to hire an attorney, or
I'll probably just have to take like a state appointed one or something like that, and then I'm going to plead not guilty.
Okay.
Yeah.
I'll enter a not guilty plea for you.
Okay.
And can you afford your own attorney?
No.
Okay. I just have to confirm that you're eligible. So what is your monthly income?
Well, right now I don't have a job. I'm currently actively looking for a job. I went and applied 6 places yesterday, so we're looking up, but right now I don't have any income.
Okay, so you are qualified for an attorney. I'm impressed by your diligence applying at that many places. I hope you get a job soon.
Me too, thank you.
So we're going to appoint John Quitner as your attorney, and you'll get his
what's the name?
John is his first name.
Okay.
His last name is Quitner. Quittner.
Okay.
And we're going to send you his contact information. Though I think you might need to give the court an address, because the address we have in the file, I think, is your mom's address.
It is. I wanted to ask you a question about that. Like, I don't know if there's any way that you cannot do a no contact order, because if she doesn't want me to talk to her, like, I'm not going to violate that, that privacy of hers. I love my mom, just things got a little out of hand, and if she doesn't want me to talk to her, I won't talk to her. You know what I mean? I wouldn't violate that.
So the situation I'm in is right now, you are charged with assault in the 4th degree, domestic violence. That is a serious charge. I'm not saying that this case won't be resolved.
Yeah.
But in the short term, whenever we have a crime like this where violence is alleged, the court typically has to enter some kind of pretrial no contact order until the matter's resolved. So largely speaking, my hands are tied on that point. I think I have to do that. I appreciate, I see a lot of these cases, and a lot of times it turns out the parties, get it sorted out, and it's a short-term thing. But
yeah.
So
with
that in mind, what I do need to know where the court can contact you. Do you have an address we can send mail to?
Not really. I could come pick it up.
We can't. Unfortunately, we still got City Hall walk through because of coronavirus.
Yeah.
You don't have an address you could just get mail out, like a friend's or.
Not at the moment. I'm just kind of new in town, I've only been here for like a year, and I don't really know a lot of people, to be honest with you.
I understand. Well, how about this? What if we sent it to your name at South Bend Post Office General Delivery? Would you be able to get it?
Yeah, if I just go to the South Bend Post Office and ask them for some mail sent to my name, yeah, I could get that.
It's a small enough town that kind of thing's fairly easy to coordinate, So we'll do that.
Yeah.
Do you have a pen handy?
A pen, yes, 1 second. Got it?
Okay, you do?
Mm-hmm. You?
Okay, I'll give you your next court date and also your attorney's contact info. Okay, that way in case there's a problem, you'll know what's going on. Your attorney's name is John, and his last name is Quitner, like I said before, Quittner. His phone number is 360-642-3139.
3139. Okay.
And you can give him a call tomorrow. He'll be around.
Okay.
And your next court date will be March 10th. Same time, same situation. You'll appear by the phone.
Okay. Same time, Zoom. Okay.
Yep. And Mr. Quitner will tell him, what you need to tell him about the situation. He can talk to the prosecutor. Maybe someone can talk to your mother, and hopefully something can be worked out between the parties, okay?
Okay, sounds great.
Now,
Thank you so much.
I guess I should ask you one final thing. Because I'm entering a no contact order, do you have items you need to get out of the house? You need a police?
I do, and but I already went over there just the other day with I think the sheriff or something, and he helped me get a few things out, but it was a limited, there was limited time for me to do that, and
So you've already done that then. It's not meant to necessarily be a full move out. It's just so you have some items to operate with during the interim period. Okay, then talk to your lawyer if there's any other issues that need to be addressed. He can bring them to my attention, and we'll be on for March 10th. Okay.
Okay. Thank you.
One last, Mr. Duncanson, I was going to enter a pretrial no contact order with the alleged victim. That seem appropriate to you?
Yeah, that's fine.
Say one more time. Oh, sorry. You're talking to somebody else.
Or something about your case, ma'am. Okay. All right. That's it.
Okay.
Okay.
All right. Thank you so much. Okay.
Have a good day.
Okay. You too. Bye-bye.
Okay, next one.
Hello? Hello, is there someone there? Is there someone there? Okay, we may need to move on if we have more to move on to.
Hello?
Hello?
Hello? Hello? Hi.
Hi, who is
Hello?
this? Yes, who is this?
This is Tabby Palmerton, and I had court.
Oh,
with
yes.
You guys, I think.
Yes, we had you earlier on, and we weren't able to your phone. We weren't able to hear you on that phone. So, Mr. Palmerton, your case got set over because we had the other judge hearing it. This is Will Penoyer talking right now. As you'll recall, I can't hear this case because I'm prosecutor on it and in Raymond. So your case got set over to, when did his case get set over to, Madam Clerk?
March 10th.
Mr. Palmerton,
March 10th?
March 10th?
March 10th?
Yes.
Okay, so I missed court too yesterday, or I think it was on a Monday.
That's in Raymond.
And yeah, I'm gonna get that fixed. I've been working, so it's I can't. In Raymond, I think you have to make an appearance, and I just started the job. I can't really lead it.
Okay, well, call the clerk over there and ask to have an appearance. Okay.
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 I will.
All right. So you're on for March 10th on this court, and call your attorney. Okay.
Yes, I will.
Okay.
So this is South Bend Municipal, right?
Yep. Yes, it
is.
Yes, this is South Bend Municipal, and I heard you ask about Raymond. I told you to give the clerk over there a call to get that sorted out. Okay.
Okay. All right then. Okay. Thank you.
Thank you, Mr. Palmerton. We'll see you on March 10th.
Okay. Hello?
Hello?
Hello? Can you hear me now?
Yes, I can. Who is this?
Yeah. Okay.
Who is this, sir?
My name's Tony Swanson.
Oh, okay, great. Hi, Mr. Swanson. My name is Will Penoyer. I'm the judge for the city of South Bend. And I am looking at your case. What is Mr. Swanson on for today? Is this his first appearance?
Yes, this is arraignment.
Okay, I see. All right, Mr. Swanson, you're on for arraignment today. This is your first appearance in
Yes.
the driving while license suspended case. Okay?
Yes.
So today I'm just going to read you your rights and see about if you need to have an attorney appointed, okay? And you
Okay.
get a not guilty plea. So
Right.
you are charged with driving while license suspended in the 3rd degree. That's a misdemeanor, which means the maximum penalty is $1,000 fine and 90 days in jail. That's not what you're likely to get. That's just the maximum penalty. You have the right to remain silent. You don't have to say anything about this case today or in the future. You don't have to say anything at trial if you have a trial in this case, and that cannot be held against you. You have the right to have an attorney. If you can't afford an attorney, one can be appointed for you. You have the right to have your guilt decided by a jury, and you're presumed innocent unless proven guilty in front of the jury. You have the right to be present when evidence is being presented to the jury and question witnesses against you. You can call witnesses to testify for you, and that could be prepared for you at no expense to you. You have a right to a trial within 90 days from today if you enter a not guilty plea. If you're found guilty at trial, you have the right to appeal that finding to an appeals court. If you plead guilty, then you have limited appeals rights. As I said earlier, your charge is a standard misdemeanor. I've reviewed the police reports and I believe there's probable cause in this case. That doesn't mean that I'm finding you guilty. It just means that there's enough in the report to support the charge going forward. Do you understand your rights and the charges?
Yes.
Great. At this time, would you like to enter a not guilty plea?
Yes.
Okay. And do you plan to hire an attorney?
I don't have the funds, no.
Okay. What's your monthly income, sir?
Right now, I had to take a leave of absence due to medical, so I'm not working right now.
Okay. In that case, you do qualify, so I'm going to appoint you a public defender. And his name is John Whitner. We are going to send you his
Don?
contact. Yeah. His last name is Whitner.
Okay.
If you have a pen, I can give you his, name and number.
Yeah. Yes, I got a pen.
Okay. His last name is Whitner, Q-U-I-T-T-N-E-R. And his phone number is 360.
Okay.
642.
642?
Yep.
Okay.
3139.
3139.
Got it.
And his first name's Don.
John with a J.
Oh, with a J. Okay.
Got it.
Got it.
And Swanson, we are going to set the court date. Your next court date is going to be on March 10th. All right.
On March 10th?
Yes. So give your attorney a call, and he can help you work through the process. Okay.
Okay. Thank you.
All right. We'll see you on the 10th, and give John a call.
Okay. Thank you.
Thank you, sir. Have a great day.
You too.
Okay, I'm gonna circle back to one that wasn't responding earlier.
Okay. Oh, okay. This is Ballesteros, isn't it?
Pete had to go.
Oh, he did? Okay.
Her daughter may be on hand to help us out.
Okay. So, can you hear me okay, ma'am? Okay. I can't hear her. I can see her speaking, but I can't hear her. Yeah, some reason the sound's not working here. So, can someone tell me what we're doing on this case? I guess just so we have an idea. I'm not gonna go through anything without her hearing, but I just want to see where we're at.
We have a resolution agreed. It's strictly up to her signing the pleadings, which I have sent to her. Mr. Duncanson made us an offer that was good for us to accept.
Okay, so we don't need, so in other words, we wouldn't have it resolved today anyway.
Because we don't have the pleadings, yeah, I suppose, yeah.
Okay, so that's, you know, no harm, no foul then. So I don't know, is there a way we can let them know that we're just gonna continue this to the 10th and to get the paperwork entered, or?
Yeah, I could go.
Okay. I guess that makes sense then. We'd already addressed the pretrial release issues, right? The no contact order, that was already addressed, I think. Didn't we clean that up?
Yes. Yeah, no, that should all be already resolved.
That's what I thought. I thought we already dealt with that. So there's no urgency here, really. All right, that was what I was concerned about. I guess then just let them know that we're going to continue this to the 10th and to talk to her attorney and get it signed.
I messaged her.
Okay, great. Okay.
I think she can't hear us.
Right, I know she can't hear us. That's okay. Hopefully she'll read her message. Okay, I see another number down there.
Last one we have.
Is this the one that wasn't working before?
Mhm.
Hello? Hello? Hello?
Oh, I know who that is.
You do?
I do, and it's not somebody that is in South Bend Court. I was appointed to her in North District Court. I have no idea why she's on the South Bend call. Her name is Brianne Gray. You don't have her on your docket, do you?
Sure that
Oh,
that's,
yeah, we do.
don't we have someone with that name?
Yes, we have
Oh, is
Brianne
she
Gray
for
on for driving unsuspended for arraignment.
Yes, interesting.
Yeah, we do have a Brianne Gray. However, we may have to continue arraignment on that because we're not hearing anything. Hello? Is anybody there? Okay, well, it doesn't seem to me that they're able to hear us through the technology issues here. So I guess I'm going to have to put this on for continued arraignment to the 24th.
Okay.
I realize John won't be here, but we can. I assume John will probably be appointed, given that he's already been appointed to her in North District.
Okay.
All right. So who do we have?
Well, give me just a second. I think I just heard Kim on the phone with somebody.
Oh, of course.
She was giving them login information. So
Okay,
we can just give them a few seconds, see if they pop on. And
of course, patience is the name of the game with these cases. It's soon, I mean.
what do you want to do with Mr. Nunes' case?
Well, let me get some input from Mr. Quittner on this.
Which case we talking about?
Nunez.
Okay, Mr. Nunez, I honestly think the language barrier has resulted in him thinking it's just done or something, and I think me and Pete need to team up on it. We talked to him about, the resolution that we agreed to is completely reasonable. He's highly in favor of it, and then he didn't show up to court, so I'm a little worried that he just thought like, oh, it's done, and I think I might need to clarify that for him. So I asked the court not to issue a warrant. I really don't think it's willful.
Wasn't he not here last time too?
Yeah.
Okay. Well, if there wasn't a language barrier, I would be kind of reluctant to not issue a warrant at this point, especially given that it's a DUI case. But I take Mr. Quittner's point here. I guess what I am saying though is I can't, predict, you're not supposed to ever say for sure what your rulings will be, but I guess I can say that I'm going to be fairly unlikely that I'm going to want to continue this yet another time when we've got a DUI out there floating around. So I guess, can you talk to Mr. Hinton, Mr. Quittner, and see if we can get a hold of him and bring him back into the mix of things?
Yeah, I'll call Pete right after court.
Okay, I appreciate that. And we'll just note an FTA and move on. Note it for the 10th, I guess, since John won't be around the next date.
Okay, we have somebody on now.
Okay.
Okay, I can hear you now on the regular phone, but I can't video, I guess. I don't know what it is. I can't hear you on it.
Who is this?
This is Pamela Martinez.
Oh, okay. Is this on, you don't have a case, right? You're here for somebody else?
No, I've got driving while under suspension.
Oh, okay. I'm sorry. I mixed you up with somebody else. My apologies, ma'am.
I'm sorry.
That's
I
my
was
fault.
Pardon me?
Nothing. It was just the misunderstanding is all my own. So, Miss Martinez, you're on for a pre-trial today. Mr. Quittner, what are we doing?
Well,
Pardon me?
I got it, Pamela.
Hold on a second.
Okay.
We have I think she's got a good crack at getting her license back, but she's got to wait for a stimulus check to come. So, assuming we have speedy trial time, and if not, we'll waive it. We're just going to have to set this out till March 10th.
Okay, when was Miss Martinez arraigned?
Sorry?
When did we do arraignment on this case?
When did we do arraignment?
Right.
What's that?
Just wait, Miss Martinez. I'm asking the clerk something.
Okay.
(10/22/20).
What's that?
October 22nd, 2020.
October 26th. 22nd?
Don't, Miss Martinez, just wait a second. We're figuring something out, okay? Just hold tight.
Pardon me? Okay.
Just hold tight for a second. I'll let you know when I need to talk to you.
Okay. Looks like we did put in a speedy trial waiver setting the new commencement for December 15th. Does the court have that?
Yeah, but that if we're moving this to March 10th, then that's not going to work. You see what I'm saying? That's going to put us like March 20th for the end of it.
Right, right. Okay, so
So, Miss Martinez, what your attorney is telling me is that he wants to give you a little bit more time so you can get your license and get a better deal on this case. But you would have
go ahead. I'm sorry.
You would just need to agree to waive your right to speedy trial for a little while longer so that you have time to get your license. Does that make sense?
Yeah, I'm waiting for the stimulus because I can't afford it because I pay rent and I ain't got nothing left.
I completely understand, ma'am, and I have no problem with that. We just have to make sure that because you have a right to a trial within 90 days, we just need to make sure you're waiving that if we're going to put something out that far. Okay?
Okay, I hope I can pass it. I'm gonna try.
Your attorney will talk to you about it. John, if you can just get a waiver from her, we'll call that good and we'll set it for March 10th. Is that enough time, March 10th?
Yes.
When do you get your check?
This is February. Pardon me?
When do you think you're gonna get your check?
I'm just waiting on the stimulus right now. I don't get paid till the 26th of every month.
When do you think you're gonna get your stimulus check?
They were supposed to all be getting it soon. From what
Some people have got theirs and others haven't, just like last time.
Okay, I just don't know. I know I haven't gotten one, but okay, well, that's fine. We'll just say March 10th. If we need to bump it out a little longer, that's fine.
March 10th?
Yep. Talk to your lawyer, ma'am, and we'll be back on March 10th.
Okay, thank you. What time?
Have a good one.
1?
I said have a good day.
You too. Are you there?
Yep, you can hang up, ma'am.
Okay. Oh, okay. Sorry. I thought I was
Okay, nobody left in the waiting room. We have one case, Tyrone Dixon was on for arraignment.
That's it?
That's it.
Just looking through my stats here. Tyrone Dixon, okay.
I got to jump off. I have a meeting I'm backing up against. So
okay, that's fine, Mr. Duncan. Thank you.
Okay, thanks.
See you later. So we just have this one non-appearance here. John, you don't have to stay on then. Okay. Okay, so Dixon, he was given something notifying him of this date?
Yes, it was sent to multiple addresses. It was sent to a Kent address. It was sent to a Seattle address. 2 different Kent addresses and 1 Seattle address. It was sent to.
All right, I'm going to issue a $500 warrant.
Okay, that's
Other
it.
than that, Madam Clerk, I'm gonna draft the other. I'll sign whatever's sent to me, but I'm gonna draft the no contact order on the shiny case. I'll take care of that.
Sure.
And I'll send that in to you.
Okay, great.
Thanks for all your help.
You bet. Thank you.